Tonight, the Supreme Court justices saying some interesting things when it comes to the gay marriage case that could impact millions of Americans. Now, our legal panel is here to hash it out and also to try to figure out how this court will rule. Then, we have seen violence and looting in Baltimore, but most of those folks did not even get arrested. And we're asking whether there are different rules for crimes committed during riots compared to crimes committed on other days. Also, Yankees, well, they lost today, but they are certainly facing a major milestone or major milestones. Are they supposed to pay A-Rod $6 million for the next home run he hits because it'll time with Willie Mays, even though the whole marketing value is through the window? We're going to get into that as well.
This is the Giants' revenge.
Okay, Mark Furnish can't help it. He's already talking. All right, good evening and welcome to RFL. I'm Richard French. And we do, of course, begin with the gay marriage case before the High Court and some supremely mixed messages coming from the justices. Now, when you listen to what Chief Justice John Roberts had to say about the case yesterday, you wonder whether he will wind up supporting gay marriage. Take a listen for yourself.
If Sue loves Joe and Tom loves Joe, Sue can marry him and Tom can't. Why isn't that a straightforward question of sexual discrimination?
Now, many consider obviously the swing vote here, Justice Kennedy. He said this about whether the Supreme Court should widen the definition when it comes to marriage to include same-sex couples.
This definition has been with us for millennia. And it's very difficult for the court to say, oh, well, we know better.
All right. Well, to weigh in on this, let's bring in our panel and ask them. Brett Ward, new to the program. He's a partner at Blank Rome LLP. Doug Von Oys joining us. He's a founding partner of Carson Von Oys, focusing on corporate misconduct. And as we know, of course, here, selected by the Legal 500, is one of the most influential trial lawyers in the nation. Mayo Bartlett, attorney at the law offices of Mayo Bartlett, PLLC, and former chief of the Bias Crimes Unit at the Westchester County DA's office. And Mark Furnish, professor of Brooklyn Law, and he has argued before the U.S. Supreme Court. And we're going to be talking about, obviously, this case, guys, but also the idea of letting all of us see it, cameras within the Supreme Court. It'll be very interesting to get people's perspective. I'll start with you. Brett, the idea of where the court is going, there seems to be two principal questions they really have to answer, right, as to whether or not this is an inalienable right, and then also the state's rights. Do I have it correct?
Yeah, I think that's the competing principles here. I think that the state rights, leaving it to the voice of the people, the voters, and leaving this issue to state. Traditionally, family law has been left to the states as a federal court exception that they say they're going to keep their hands off of family law issues. But at the same time, there's a fundamental right question, which and also an equal protection question. And it goes back to a definition of marriage, whether the fundamental right of marriage is just absolute or whether it's a fundamental right of opposite-sex marriage, because that's really rooted in the history of every society that there ever has been, and that was a point that they made.
You have a special connection to this. You've had clients here who've tried to navigate this issue. Put a human face to it, and I'm curious, with a lot of your clients, were they eager that the Supreme Court's taking this up to give clarity to this so it's not an issue defined by where state lines start and end? Or are they nervous that, wait a minute, all the gains that have been made in different parts of the country, different states, could all of a sudden disappear if the court rules 5-4 the other way?
Well, I think generally speaking, people are excited about this. They consider it a civil right. They want to be recognized like every other person. They think that their love should be valued as any other person's love, and this is an opportunity for them to be recognized. They had some success with an earlier case, United States versus Windsor, that struck down the Defense of Marriage Act. They think the momentum is going in the right direction, and I think almost uniformly, people are happy, same-sex couples are happy that this issue is now before the court and it's being discussed whether this is a real civil right.
You know, which marks a really interesting change on the part of advocates for same-sex marriage, because as Brett will attest, in the beginning of this debate, a lot of them were very reluctant to leave it to the courts because they felt that the courts were out of step with a growing popular tide in support of same-sex marriage. With the increasing success they've had among lower courts, that view has done pretty much a 180, as I think Brett is confirming.
You know, to that end, Mark, court watchers, it's a dangerous game and trying to divine where judges are based off of questions. But nonetheless, the question that was asked by Justice Kennedy to say, we survived for thousands of years here with an idea of what it is. Who are we to basically decide? Do you take these as smoke screens, or do you say, whoa, if everybody thought he was the fifth vote, maybe we shouldn't jump the gun?
Well, it's dangerous, as we've said on the program many times, to cherry pick these comments out of context. But if you read the full transcript or you listen to the argument, everybody was framing their arguments, at least on the petitioner's side, in terms of human dignity. This is a famous Kennedy buzzword. If you read the Kennedy opinions over and over again, he's huge on dignity. And as the argument went on, when it came time for the defenders, those opposed to gay marriage, to defend their statutes, he went at them very hard on the issue of dignity. So I think this is a pretty easy one to tell where it's going to go. We already know that there are four, no pun intended, and 3 against. Kennedy is going to come out in favor, I think, of a sweeping right to gay marriage under the Due Process Clause of the Fifth Amendment. I also think that Roberts will come down in favor of it for the reasons we discussed in connection with Obamacare. He's very sensitive as the chief to the court's legacy, doesn't want to be on the wrong side of history, concerned about public perception. I think it's going to be a 6-3 decision. He might not embrace a due process right, might go on the more narrow equal protection ground under the 14th Amendment. But I think the writing's on the wall for this one.
Joe?
I think so. I think it's also one of those times where it's good to have a bench that's not being elected. Because if they were being elected, and we've talked about this a number of times, then you start to look at all the political considerations and how's it going to play in your local jurisdiction, as opposed to what does the Constitution really cry out for.
You know, for me, Doug, if they didn't, if the majority of the court does not come down here supporting gay marriage, imagine what happens later. We've seen the velocity of public opinion go so strongly towards this, and if you look generationally even, forget that the majority of Americans support this. By the month, it seems to go up 4 or 5%, and you look at the younger generation, it's like 3 to 1, if not even greater. What then if it doesn't? Where does public opinion, do you think, factor into A, taking the case, and then B, coming down to where seemingly public sentiment is driving the issue?
But I think there's a way of doing it without saying it's not a fundamental right. I mean, if they say it's a states' rights question and they decide it's not our place to do that, that could happen. They could do it without saying, you know, we don't believe in it.
But there doesn't seem to be that much appetite for that sort of resolution. That's the second question, what they're calling the recognition question. I don't think they took this case to do that. Because first of all, they reached to take the case. It's not really ripe yet. It's premature. It's very early. And they didn't have to wade into this if they didn't want to. So you know there's going to be some sort of political statement made in this case. And second of all, not only did they reach for the case, they actually framed the 2 questions. Not unprecedented by any means, but highly unusual in Supreme Court litigation.
There is some concern, though, of a compromised decision here, because the second question says, well, if we don't recognize an absolute right for same-sex couples to marry, do states have to recognize those marriages solemnized in other states?
And that's what this poll, in fact, recognizes. Nationally, we just showed that more than 3 out of 5 Americans support the idea of gay marriage, but the idea that the Supreme Court should decide for everybody, it's pretty split in this country.
And there's a real issue of whether that would offer them, the court a compromised position, which is to say, go get married in a state wherever you want and come back to your state, and that state must recognize your marriage, and you will not be given a second-class citizenship. But at the same time, they're not setting forth that there's an absolute fundamental right for same-sex couples to marry. And it would be
if I could, just 1 second, because we talked about where I think the 4 of you guys agree the court probably is going to end up on this issue, and the choice to take it, as you said, they actively sought it out.
At this time, on the heels of
But
Windsor
as much
so
as you
quickly.
can, put a human face on it, where this isn't just a case that this is about lives. And why is it so important for people that they have a piece of paper that recognize it? For those folks who haven't, who don't know someone who's gay who's got married, who haven't been to a wedding of 2 men or 2 women, or who don't have that connection, why is this more than simply just a recognition?
Because it's about people being able to access family members. They're a person who they've loved and taken care of and been taken care of by someone for 50 years, and then on their deathbed they're not allowed in the hospital room because they don't have the rights of a family member. People paying estate taxes. This goes to the DOMA case, where they lived as a couple their whole lives, and then when one person dies, they're strangers. And they're taxed differently. They don't have benefits. They don't have survivor benefits. When one person makes a sacrifice and they raise kids together, and one person leaves the workforce and the other person remains as a teacher or some other person entitled to a pension, that's person who sacrificed their life to raise their kids doesn't get their pension because they're not recognized as a spouse. These are affecting people's lives every day, and it's having a devastating impact on these people aside from the philosophical civil rights argument. There's a real issue here, and these cases that came up, people not being recognized on the death certificate as the spouse, this has a substantial impact on people's daily lives.
Okay, now this case has brought up a separate question that we're going to get to on the other side of the break. We've got cameras everywhere nowadays, and we're going to talk about a different. Well, we'll get into that. You got them at traffic lights. You got them certainly in police cars, on police officers themselves. There's even a push to put them into operating rooms, but the Supreme Court still doesn't have them. And I'm going to ask the table, and also I'll talk to a top lawyer who's trying to change all that, if that's going to be good or bad for the most important court in the land.